Hello, good afternoon, everyone. This is Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. And this is our bi weekly community phone call where all of you ask questions and I answer them to the best of my ability. You've already heard the disclaimers when you logged in. Subject to those, I'll be first starting with the questions that have been posted on our website, on the forums. I should say your website, really. Um, and from there, we'll do follow up questions. And once we are finished with the follow ups, then we'll do new questions. So, first answer the posted questions, then follow up questions, follow ups to the posted, and then new questions. I actually have a couple of very, very interesting questions today, and I think eventually I'll start compiling them into frequently asked questions. The first one, which is marked as question number 2, is from W101HKA. This is a question that is asked very frequently. So I already have an I-140 approved in EB2 category, and I want to take a promotion with the current employer. But I heard that if I change my job designation and responsibilities, it'll have consequences. That is true. That is true. This is a very, very unfortunate problem. See, when the labor certification process was originally implemented many, many years ago, it used to take, when I first started my own, it used to take about 6 months, 4 to 6 months for the whole green card process. And the concept was because green card is being offered for a specific job, you should not change the nature of that job while the green card is still being processed. Nobody had ever thought that it will take 9 or 10 or 11 years to procure a green card. This is one of the most tragic and horrendous things about the green card process, that during those 9, 10, 11 years that you are waiting, you are not supposed to change the job description, title, salary in any substantial manner. Okay. But here in this case, what if I'm getting a promotion? What should I do? Well, you will have to start the green card process all over again. But you will carry the priority date of the old case over to the new case. You should have your lawyers review. Sometimes the changes are insubstantial and they may not require filing of a new green card. But if the changes are substantial, you should have to and you will have to file PERM again, I-140 again, pretty much. Okay. Can I use my existing application? No. If I cannot use my existing application, can I port my priority date? Yes, you can. I have gained all my experience with my current employer. Can I use this? And the answer there is also yes. This is another question we get asked quite often. Can I use the experience gained with the same employer? The answer is yes, you can. You can use the experience gained with the same employer if the job that you did for them, the experience of which you want to use, and the job which you are offered are more than 50% different. So let's say I started with them as a programmer analyst, and the job being offered to me is a team lead, and the team lead job involves a lot more leadership role than actually hands-on technical work, and the technical work is qualitatively and quantitatively different, then you can use the experience gained with the same employer. Are you on the call right now? I'm going to, because this is a frequently asked question, I want to deal with all aspects of it. So anybody, including the person who posted this question, if you have a follow-up on these issues that I have discussed, please press *5 on your phone. Press *5. One raised hand. Okay. Go ahead. I actually answered. You were the first one on the call. You've been here a long time. Go ahead, please. I can hear you. New Jersey?
Yes. So my question is the if I have to think about whether there is a 50% or a significant difference in the current job and this new job, if the answer to that is probably say no, then what are the options?
Um, you could go with the experience that you have before the job. You could go with a higher degree if you have a master's degree that can be used. Um, and frankly, if the job is less than 50% different for what you from what you've been doing, is it really a significantly different job? That's a decision that your lawyers have to make with you. They should look at the profile of the old job, profile of the offered job, and of course, err on the side of being conservative. You don't want to be too aggressive about your interpretation. Oh, this is substantially similar, and in the end up causing a problem for the green card process. So they should evaluate it, because if you are telling me the jobs are different but not more than 50% different, then my next logical question is, are they different enough to warrant a new application at all?
Right. Okay.
Okay?
Okay.
Good luck to you, sir.
Thank you very much, sir.
My pleasure. Bye bye. Okay, let's get back to our questions. This one is taken care of. Question number 3, H1B salary Gupta. Now, here what has happened is he's on H1B or she's on H1B, and employer has applied for H1B extension. But for the first 2.5 years, employer paid less than what was required under the LCA. Now, when this was brought to the employer's notice, they want to fix it. They said they'll give a notarized affidavit which says that they have supplemented W-2 for those years. Is this legal? And the answer is definitely that's a smart thing to do, because if an employer has made an error and they voluntarily come and correct that error, government looks favorably upon that situation. Is it 100% fix? Can this prevent any problems? The answer is no, it's not a perfect fix, but it should be a pretty good fix. That's just a judgment call. Okay. Um, let's say you can't change jobs for personal reasons. What are the ways in which he can compensate? Just remember, the compensation has to be that in which taxes are deducted. So if they compensate you like as a per diem, where they don't take off taxes, that's not salary. Salary is that part where your proper federal taxes and social security, etc., are deducted. Okay, and it can affect your green card process in a couple of ways. One, USCIS can raise an issue. Do you really have a job with an employer who can be trusted to tell the truth? And if not, they can reopen the whole green card process. Second thing, it can affect the ability to pay wages of the employer. Do they have the money to pay you? So these two ways it can affect. But if an employer willingly steps in and pays back what you are owed and provides a good, reasonable explanation, truthful of course, for the reason they did not pay in a timely manner, I think you are as well protected as you can be. If you are on the phone, press *5 please. I want to take your follow up right now. Press *5. You are here. Okay. Um, let's unmute you. North Carolina, go ahead please.
Thank you for answering that. And I did not get, like, can you give me a notarized affidavit that he supplemented W-2?
No, they actually have to give you the amended W-2s. I am not a tax lawyer, and my knowledge of taxes, as I have said, is quite feeble. You want to talk with a CPA and see if this can be done. I think it can be done. It actually, the employer will have to undertake a lot of expense, but it can be done. And I think, again, that's my guess, they'll have to give you amended W-2s.
I'm under W2 for past years or for this year, which includes past wages.
I am not sure how this is done logistically, but the idea is that they are paying you for the money that they owe you from past years.
Okay. So, and like you said, that they have to pay it in a way that taxes are taken from it.
Exactly.
And suppose they don't do anything right now, and when it comes up, they are willing to fix it that time. Will that be okay?
No, it should be fixed ahead of time. Because if they do it upon an inquiry from the government, it doesn't carry that much of good faith with it.
Okay. Thank you. So I need to ask them to give me my past wages, basically.
That's what I would recommend. This is not a 100% fix, but this is as close to a good fix as you can get.
So what would be other fix?
I don't think there is any other fix. Looking for another job would definitely be a fix, but you are not in a position to do that. So I think we have to go with the next best.
Okay, sure. Thank you so much.
You're welcome. Good luck.
Thank you. Take care.
Bye-bye. Okay, let's move on to the question number 4. So after 7 years of working in the US with a TN and an H1 visa and mountains of paperwork, I hear you. It is mountains of paperwork. I have finally received my LPR status. So I have the 551 visa in my passport, but I have not yet entered into US. So you want to come into the US and then you want to come back and finish your commitments for the next few months and renovations before you can move back to the US. Question: when I next enter the US, can I give the address of a friend? I think that's okay. Look, the most important thing is when you leave USA, this time when you come after getting the green card, it should be your intention to return within a certain period of time. It shouldn't be forever. And I would very strongly recommend that you make it less than 6 months. So come back in less than 6 months and establish your permanent home in the United States. Find a job here. Okay. DHS, USCIS can definitely create a problem for you. They can come after your green card. Okay. Can you return home while the PR card is being issued? Yes, you can, but you should go get. I'm not sure if with the 551 visa stamp you need this, but it's a good idea to go to the local USCIS office after making an InfoPass appointment and asking them whether your passport should be stamped for travel. They also have a stamp which says processed for permanent residence, temporary proof of I-551, etc. If they say you don't need it, you've got the visa, I think you're okay. But it's best to double check that. Okay? So just keep these legal principles in mind. Next question is number 5. Excuse me. From visas, which query? I'm working on H1 visa as a consultant. Contract is coming to end on May 9th. Spouse is a Canadian citizen working on TN. So I plan on changing to TD. On which day should I apply for TD? You can do it online. So you should apply it perhaps the day before your last day at work. You can change back to H1 only if on the day they decide your H1 application. So now you have a TD pending. On the day your H1 is decided after application, your TD should have already been adjudicated. If it is not adjudicated, they will make you go outside for visa stamping. You may also want to consider just going to the border and coming. Oh, well, you can't go to the border. You've got to go to the consulate for a TD visa. So another option is to just get a TD visa and come back. Okay. So the only downside of applying and having a TD pending is that if you apply for H1 on the date the H1 is adjudicated, your TD should have already been decided in your favor. If not, they'll ask you to step outside, get a visa stamp for H1 and come back. That's the only downside. And you cannot start working with the new employer. Well, that's a little bit complicated discussion. But as a general rule, unless you're already validly maintaining status on H1, you cannot start work on portability with the receipt with a new employer. There is an exception to this rule. Discuss it with your lawyers. That may or may not apply in your case. I don't want to get into it. It's a long discussion. But there could be an exception. You may be able to start working on H1 even while the TD is pending. Double check that, okay? Next question is number 6. So dad, from DK Doshi 18, dad applied for unmarried brother above 21 in 2007. But the brother got married. Can my dad get citizenship and file for married son by converting? To the best of my knowledge, you cannot convert. You cannot convert because your brother lost his eligibility before you could get him converted. Okay. So if the order had been that he was still unmarried, father converted his case and then he got married, he would be okay. To the best of my knowledge, that's the way it works. Okay. B. Shilpa, October 30th, 2013, got H-1B approval. Employer is a Florida-based company. LCA is also for Florida. I'm a web developer. I can work remotely from anywhere. Moved to New Jersey from Georgia. So the question is, my LCA is approved for Florida, but I'm living somewhere else. Is this okay, even though I'm working remotely? I don't have a good answer for you. I can tell you what I do, because US Department of Labor does not have a good plan or a good way of working with these remote work sites. What we do is, if you are going to visit the employer's office or the client's office, we will do an H1 that covers, or an LCA that covers both your home, the employer's location, or if you are going to work only with the client's location. Okay. So we cover the two locations where you are actually going to be performing the work. Okay. It's a little complicated. The Department of Labor has been struggling with this issue. One of the problems that comes through is, where should the LCA posting notice be placed? And from what I recall, the last time they spoke to this issue, Department of Labor said, let's say you are working from Georgia, your employer is in Florida, but your end client is in California. We want you to place the posting notices in California where the end client is. So keep these issues in mind. And I think if you go for visa stamping, they can create a problem. So your questions are, is my LCA valid, or do I need to reapply? I answered that. I think you need an H-1B amendment. Do I need 2 LCAs? You only need 2 LCAs if you are going to be working at a site other than your home. Will my H-1B stamping be denied? Probably. My employer did not revise my salary. That is another problem. The salary must be according to the place where you're working from. My husband is a consultant. I'll be moving more often with him. Will this affect my LCA? You'll have to do an H-1B amendment every time you move more than 40-50 miles, more than normal commuting distance from the already approved LCA site. SRAVs. I work for employer A. I have an approved labor I-140 EB2. Currently I'm on H4. Spouse H4 is going up. So my plan is to either come back to H1B or F1. F1 is going to be difficult because you have an I-140 approved. Okay? Because once you have an I-140 approved, your exhibited immigrant intent, the government may not give you an F1, although they are very inconsistent about this. So if you're an F1, can you directly apply for 485? Yes, you can. You can. There are some technical issues there about whether you can maintain an F1 along with the 485, but it's not a big problem. talk to your lawyers, they should be able to fix it for you. But theoretically at least, it is possible, it's done all the time. Can you suggest any good university around Virginia area? I have a video on how to find out if a university is properly accredited. Go to my blog, and I have a video on how to do it. But all the good universities like the state universities, UVA, Virginia Tech, William and Mary, all these good schools, George Mason is a good school. So I don't know, what you're looking for, but I cannot really tell you that I'm an expert in universities. I just said what I said from what I know as a resident of Virginia, not as a lawyer. Next question is Arrow35. So he's on H-1B, got engaged, wants to invite fiance on visitor's visa. Don't do it. Don't do it. Everything that you're planning could end up being considered to be fraud. And if it is fraud, she can be barred from entering the United States forever. Very difficult to get waivers for these cases. My recommendation, let her go in. If you want to try it, let her go in by herself and say, look, my fiance lives in USA, I want to go visit him. They're probably not going to give her the visa, but at least she will not be barred forever. Everything else you're planning, I have real problems with it. Okay. Next question, green card processing. Once I-140 is approved, how soon can I change jobs? Do I need to wait for 6 months before going for any job change? I think you have posted this message on immigration.com also. And I have said, if you want to carry the priority date, you don't have to wait after the I-140 approval. The moment the I-140 is approved, the priority date is your property already. Does premium processing of I-140s bring more RFE? Not in my experience. I don't think premium processing generates more RFEs than normal cases, but that's my experience. I'm on H-1B. This is SCS 777, question number 11. I am on H-1B with my current employer. They filed green card, EB2, 2009 priority date. 485 was filed 2 years back. You have an EAD which is good for the next 1 year. Got the labor and the I-140 documents by FOIA. I want to change my employer and I have the following concerns. Employer is definitely going to revoke the approved I-140 after I leave. Am I going to be completely fine with the AC-21? Yes. If the jobs are same or similar and you have your labor, you can have your lawyers compare the two jobs, the one that you are going to and the one that was in the labor. If they are substantially same or similar, you are fine. At any point of time in future, will I need the original approval letter of I-140 or labor? No, you won't. What are the documents I should collect from my current employer? I don't see what else you need. I think you're fine. Is it okay if I join as a manager? I don't know the answer to that question. That's a very thorny question. Some people have, because the law just says same or similar job. Some people from the bar would argue that same or similar means as long as it is the same general area. And if you're a technology manager, so what? Okay. Some others would say no, a managerial position may be a different position altogether. So you don't want to change. If you're a technical person, remain a technical person. I do not know the answer to this question, and I don't think anybody can answer this question for you. Is it possible to get confirmation from USCIS on my new job duties? Of course not. Of course not. That'll be too easy, right? That'll be making things too easy for us. No. They don't give you an opinion on whether this is okay or not. Is it possible to open a company on my name? And I have a video on this. Go to my blog. It is the last entry. I had a very long discussion with Santosh ji, a gentleman from our community. Almost an hour long conversation, or half an hour, 40 minutes long conversation, exactly about this question. Okay? Read through that, listen through that. If you still have questions, get back here. Last question of the day, Venom 30. Me and my wife are currently on green card. After living in the US for 7 years, we moved back to India for good in November. I'm working with the same employer for their Indian subsidiary. Plan to apply for N470. We've been visiting US every 6 months. Completed 30 plus months of physical presence. Also received re-entry permit. Can we apply for N470? Look, I don't remember all the rules of the N470 off the top of my head, but there is something that you should have 1 year of stay in the United States where you have not left US even for 1 day. Any time after getting the green card. If you don't have even 1 year like that, you cannot apply for N470, from what I remember of the rules. Second rule is you can apply N470 within 1 year of moving out. I think that is correct. Home address, mailing address, will it be okay if we put our US address as both home and mailing? I think so. I think so. According to the new rules for N470 published in Jan 2013, looks like employer confirmation, affidavit, etc. is no longer required. We always file it. I am not sure what rules you're talking about. We always get a letter from the employer. And the employer should clearly state that they are an American-owned company, yes, of course, engaged in the development of foreign trade for US. Point number 14 on N470. Let me caution you, I cannot help you fill forms, but let me see if I can address the area generically. Oh, you can always attach a separate page. You can always attach a separate page. If you have an answer to a question that goes too long. And again, if they say explain your employment position, do the best you can within those 3 lines. I don't think you need to get too detailed about this. I think 3 lines should be sufficient. But you can always add an attachment sheet. The last question is, when will I be eligible to apply for naturalization? 5 years after green card or 4 years and 1 day after green card? Interesting question. Actually very easy question to answer. 5 years after green card. That 4 years and 1 day rule applies to those people who have stayed outside USA for more than 1 year and they have broken their continuous residence. So when they come back, normally they would be required to do 5 years all over again. But if you have a re-entry permit, they'll only make you do 4 years and 1 day. That doesn't apply to you. Okay? All right. Any follow-up questions? Press *5 on your phone, please. Any follow-up questions on what we have discussed so far? *5. Only one. Any follow-up questions on any of what we have discussed? Two people. Okay, very good. 3 people. All right, we'll be starting new questions after this, but let me finish the follow-ups first. I'll go in the order that you guys logged in. North Carolina, go ahead, please.
Hello?
Yes, go ahead, please.
Yeah. My question was, I think, 6th or 7th. My dad applied for my brother. Is there any other options for this case, or as long as he got married, he's ineligible for the immigration?
Are you talking about the brother? The unmarried brother?
Yes.
Well, of course, he can qualify for an H1 or L1 or H4 or L2, but other than the EB5 option, I don't see what else you can do for the green card. I mean, the investment option.
Okay, but he won't be qualified for the family immigration in this, the way he was.
Yeah, I don't think you can convert it. Double check that with USCIS, but I don't think it works like that. I frankly haven't looked at this issue for a while, but I don't think it works like that. Okay.
Okay. All right. Thanks.
Good luck, sir. Bye-bye. Okay, let's see. Georgia, go ahead, please, Georgia. Georgia?
Hello?
Yes, go ahead, ma'am.
Hello. My question is question number 7. And I did not, frankly, I did not understand what you said in my case. I really need H1 amendment or LC amendment for my stamping.
You need an H1B amendment. Every time you move from state to state, you will have to do an H1B amendment, not just an LC amendment.
But
Okay.
and what about LCA? Is it important to mention the work sites in LCA because my employer's office is in Florida, but the clients are scattered. Since I was in Florida, I did not work from office. I always work from home. So is it okay to work from home for H1 or it is not registered?
It is okay to work from home, but the home site should be covered by the LCA and the H1 approval both.
Okay.
All right.
So every time when I move, I have to do my H1 amendment for the new place, correct?
Unless the move is within normal commuting distance of an approved site, which means 30, 40, 50 miles, and the client remains the same. If you move beyond that area, you have to do an H1B amendment. If you change clients while you are still in the same area, you still have to do an H1B amendment.
Oh, okay. So in my case, if I do the H1 amendment before my visit to India, and that time will they ask me that why for last 5 months you are not done this, and in that case will they ask?
Well, they can. They can certainly ask you that question. But if you have, as soon as you figured out that this is what you're required to do, and you have hurried to obey the law, you should be okay. I don't see any problem with that.
Okay, so I did not violate any law.
No, you did violate laws. You already done it, but you are voluntarily stepping forward and correcting it. It's not really you, it's your employer who's violated the law. You have just gone out of status because of that.
Okay. Okay.
All right?
Thank you. Thanks for your time.
Good luck. You're welcome. Okay. Virginia. Go ahead, Virginia. Herndon, Virginia. I can hear you. Hello. Yeah, go ahead.
Hello. I did not post a question, but
Then hang on. Then please. No. Wait.
Yeah.
Phoenix, Arizona.
Hello.
Yes, go ahead, please.
Hey, Rajiv. I had posted a question regarding getting the visitor's visa for the fiancé. I'm sorry, but I was not able to hear what your reply was. All I could hear was you mentioning something about being banned, but I couldn't hear your answer to my question. I'm sorry about that.
I'll repeat it. And the answer is everything you're planning, everything that you're planning is probably fraudulent. Okay? And if she gets hauled up for fraud, she'll be barred from entering the United States forever.
Okay.
Hang on. The only thing you can hang on. The only thing you can do is to have her go to the consulate, explain to them that she wants to come for a tourist visa because her fiance is in the United States, but she is going to come back, and eventually you will get married and she'll come with you on H4 visa.
Okay.
They are probably not going to give her the tourist visa, but it's worth a shot. At least she will not have a permanent bar. It is it's completely truthful what she's saying. So I don't think that should be a problem.
Okay, so if she basically mentions that she's coming over here to visit her fiance, do you think the chances are more as compared to doing any other thing?
Chances are very low, but
Okay.
Chances of getting hauled up for fraud and getting into future problems are zero because she's telling the truth.
Okay, I get that. Okay, and also one more question I had posted was in the same section I had posted was, in case worst case scenario her visitor's visa is rejected, does that affect? Will that increase the her rejection chances for a dependent visa, or these two things are completely separate?
If the denial of the visitor visa is not on a fraud ground, there is absolutely no problem with the H4.
Sorry, absolutely.
No problem with the H4.
Okay, so these are completely separate things, right?
They can be if there is no fraud. If there is
Fraud.
fraud,
Okay.
then it's a permanent bar.
Yeah, I understand that. Understand that. Okay.
Okay?
All right. Yeah. Thank you very much.
You're welcome. Good luck.
Thank you.
All right, guys. Anybody has any questions, new, old, go ahead and press *5, please. Anybody has any questions? All right. 1. Very good. Herndon, Virginia, go ahead, please.
Yes, hi Rajiv. This is Prasad. Is there any possible of priority rate move for EB2?
What you're asking me is impossible to predict. As you
Is
know,
there any possible?
as you
Heard like in
know,
September.
I can't predict that. The method through which priority dates are calculated and moved is statistical. It's not based upon a mathematically 100% accurate movement. It is based upon the State Department's calculations and projections about what the visa movement is going to be. Just generally speaking, I cannot think of a single reason why things would change drastically. Number of applicants has not decreased. Number of visas has not increased. The speed of the processing has not increased. So there really is no reason for me to assume that it's going to get drastically better. You might see some blips here and there going up, going down, but the overall movement is going to be about the same.
Okay. And the other question is, I'm actually in the EB3 and then I ported to EB2. But do I still have EB3 for EB3 date?
I'm sorry, are you saying you ported to EB2, can you choose EB3? Is that what you're saying?
Yes.
I believe that you can. I remember there was some kind of a memo from the government. I don't have a copy of it and I don't remember it off the top of my head. But there was some kind of a memo that said you could make that election. I could be wrong, but I think it's out there somewhere.
Okay. The last question is, I'm on H1B. Is it legally to do business by opening a new company? I can open a company legally?
No. The problem is an H1B holder can be a passive investor, like buying stock in the open market, but you cannot run a company. Even trying to incorporate or signing a check could potentially be problematic. So you can buy stock, but you can't run a company in any way.
Even I can open a company, I can hire someone who can
See, that is
do
like
my
running,
company.
that is like running business. In my opinion, that's risky. Shouldn't be done.
That's not legal.
In my view, no.
Okay.
All right.
Thank
Good
you.
luck. You're welcome. All right, folks. It looks like we're done for the day, and I'll see you again in a couple of weeks. Thank you all for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in
The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.